I consider to be a consumer protection bill. It was amended quite a bit. It was originally sponsored by the South Dakota Trial Lawyers Association. It now will tell us what is considered to be an unfair claims practice by the insurance company. It does provide for some real stiff penalties for violations, as well as gives the Secretary of Labor and Regulation authority to suspend or revoke a license for a violation. Thank you. If you have any questions, you can always get a hold of me.
Could you repeat the last
If
one?
you're going to have any legislation you want to promote, just get a hold of me. You can contact me by email, by email address. Thank you.
Thank you. Good morning. It helps usually to follow along in the outline. Helps me make sense. See what I'm talking about. There were not a lot of blockbuster cases this year. This outline only includes cases that appear to change the law, but the law or the decision just applied settled law. Those were not included. Very few questions of first impression this year, but a lot of refinements. So we'll start with the world of civil procedure. First one was a class action case, reversed the denial of certification of the class, and held that where there are common features on a statute of limitations defense, that is applicable to class certification, even though there may be different fact circumstances that differ among individual plaintiffs as to that defense. Second case, the Bravo Agri-Finance case, makes clear that you can't try to use Rule 60B to try to get around a default of appellate rights. Next case, Waterman versus Morningside Manor. The court here entered or adopted a more liberal construction of the relation back rule and made sure that the general test is that if the same general factual allegations are made, then an amendment, in other words, you get every cause of action, will relate that and avoid the statute of limitations that otherwise would apply. In Hewitt versus Feldman, though, we have a more strict construction of Rule 37C2, and there it makes clear that when someone is asking to admit something for purposes of trial, and you don't do so, that a reasonable belief that you might prevail on that issue justifies denying admission. So they can't come back after you for attorney's fees for having to try to prove something, even if you lost that trial. The Stern Oil case also has, I think, a more strict construction of Rule 56F. So if you are going to oppose a summary judgment motion, but you need to do additional discovery, file 56 motions to do that, you have to be extremely specific, fact-intensive about what you think that additional discovery is going to produce. Otherwise, the motion will be denied. In the world of evidence, the Bertelsen case, this was actually the third appeal from a jury verdict. And as I understand, the case has settled in the fourth trial, so there will be no Bertelsen 4. But here, under this issue, it made clear that even though evidence that ultimately an insurance company paid a claim was not necessarily admissible as to whether they breached their initial duty to promptly pay it, that evidence was admissible, certainly for punitive damages issues and other issues, and bad faith issues. In States versus Buchholz, I thought was one of the more interesting discussions of the year, discussing about what an expert can and cannot testify to. It makes clear that experts cannot, under any context or under any rationale, pass judgment on a witness's truthfulness, even if it's disguised as a medical opinion, which happened in this case. Here, it made clear that an expert opinion that sexual abuse actually occurred, that's based solely on the assessment of the victim's statements, cannot be, it's not admissible. We have a new test, or at least clarify some of the law for when other tax evidence is admissible. So State versus Chamley is gone. Under jurisdiction, the Whiff case is kind of an existential question about jurisdiction. Made clear that a court always has jurisdiction to decide whether or not it has jurisdiction. And in making that decision, even if it doesn't have jurisdiction, it can make necessary orders to preserve the status quo. Under appellate practice and standards of review, there's two cases that go together, kind of the Abanis case and, again, the Bravo Agri-Finance case. When reviewing a Rule 60B motion, it's kind of a fine distinction here. Even if it's alleged that a legal error was the basis for relief from the judgment, that's still the abuse of discretion standard. But the next case makes it clear that if the motion is determined as a matter of law based on undisputed facts, then it's de novo. Piper versus Piper, we have some new language that expands upon the principle that an error of law is by definition an abuse of discretion. Abuse of discretion includes review to determine that it was not guided by erroneous legal conclusions. In Thurman, we have a little case law that makes clear that the abuse of discretion standard is not as deferential as it once was, overruling language that has been cited up until now. In the St. John case and the next case after that, we have a couple cases that address what a trial court's power is after a remand. And in St. John, they reversed a trial court's attempt to deny a new trial even after a new trial had been granted based on the reconsideration of another ruling. And in State versus Piper, they kind of made clear there are three different types of remands. If the Supreme Court affirms, then of course final judgment must be entered. If they reverse without any qualification, just a general remand, then the mandate nullifies the judgment, the findings of fact, the conclusions of law, the prior rulings, and anything else that would have occurred. It's just as if no judgment had ever been entered. And then if it's a limited remand, then the instructions the Supreme Court gives must exactly be followed. The next case, Strong versus Gant, deals with a trial court's jurisdiction while an appeal is going on and makes clear that collateral matters that don't affect the subject matter of the judgment or repeal can still be resolved by the trial court. And here was a motion for attorney's fees and expenses that could be done while the case was up on appeal. Next case, we have kind of a modification of a standard of review related to parental rights. In Tri-City Associates, it makes clear that you preserve your record either by objecting to the other party's proposed findings of fact and conclusions of law, or by proposing your own. You don't have to do both. Either one preserves your record, but why not do both anyway? Under the issue of torts, or the category of torts, the Bertelsen case again made some more law there. $250 per hour has been accepted by the Supreme Court as reasonable, at least for complex litigation. So feel free to raise your rates. The next point on that is punitive damages have been narrowed a little bit. The court has now adopted the Restatement Second of Torts 909 officially, and it limits the situations in which you can get punitive damages against a corporation for the acts of its agent. And so there are about 4 ways you can do that now, but you have to fit into one of those categories. It's not just respondeat superior. The Patitucci case makes clear that it kind of expands the duty of a municipality, even though the state highway went through a municipality. The municipality, rather than the state, or possibly both, had a duty to maintain that right-of-way. And in the England case, kind of limited foreseeability, there a landlord was held not to have a duty to protect a neighbor's child from intentional or criminal conduct of the child of one of his tenants, even though the child was, I guess, throwing rocks from the landscape. In the Peterson case, the Supreme Court made clear that strict adherence to the case within a case standard in a legal malpractice case is not always appropriate. There are cases where that standard is not applicable. In the Gabriel case, I thought it was interesting. The court, first of all, said for purposes of this statute that gives immunity to certain public services like firefighters from civil damages, said that willful, wanton, or reckless conduct, that basically is the same thing. Those words aren't really distinguished in the statute. It just covers the same broad type of conduct. The other interesting thing about that case, though, they said that there may be certain circumstances under that standard where a driver's speed alone might be considered willful, wanton, or reckless. And I'm assuming that could also be applied in the punitive damages context. So there may be a clash of law because there's a law right now that says speed alone is usually not enough for punitive damages. In the area of constitutional law, there's a due process case. If the issue is a dismissal for failure to appear, then the only constitutional issue is whether the notice was sufficient. In the Bridgman case, it makes clear that a quo warranto action is very limited and only may be used to determine whether a person can rightfully hold an office, and you can't bring collateral constitutional challenges within that proceeding. In State v. Alka, a separation of powers case, the legislature did not delegate its authority to state's attorneys by giving them discretion about charging domestic abuse because they defined the standards under which they would do that. State v. Smith, we have an ex post facto case. Even though it changed the standards, because it only applied to new convictions, it did not violate that clause. In the insurance realm, DeSmith v. Busco, whether an applicant's statements were false or misleading is a jury question unless the facts are not in dispute, and then the court can rule as a matter of law. And it held that a representation in an application that you've not been refused similar insurance, if that's not true, it is material to an insurer's acceptance of risk. So that is something that will violate the statute. In Quinn, court made clear that if you have a dispute in an insurance contract over summary judgment language, then that's not appropriate for summary judgment. And I guess I'll skip to what I thought was probably the case of the year in the area of criminal law. State v. Thompson, we had a conviction for theft by deception based on what was essentially defaulting on a loan. And there was a 25-year prison sentence that this person was convicted of and sentenced to. And that was reversed unanimously, holding that defaulting on a loan cannot qualify as theft by deception. So that person saved about 25 years of prison because of that case. Lots of interesting cases this year. Thank you very much.
Thank you. And again, I want to thank everybody for coming out to the early bird this morning. And we've got the next one's coming up at 8 and 8:30, the next CLEs, and we look forward to seeing you all next year at the early bird.